Welcome to the 5 for 2 podcast with me, your host Adele, where we say no to careers where you're trading 5 days of misery for 2 days of fun. A place we discuss all things career, confidence, and money moves. I want to motivate, teach, and empower ambitious women to achieve more, earn more, feel more confident, and enjoy the work they do. It's all about believing you can have everything you want in your career and then going and getting it. So if you're ready, let's get into it. Hey guys, welcome to another episode. I'm really excited about this episode because it's something that's dear to my heart, but also something I've seen a lot since 2024 happening to a lot of people. Actually, probably as far back as 2023. I've seen it throughout my career, but I think it's really heavy now where companies are having to restructure and change a lot of things. This has been prevalent. So without further ado, I do have a guest this week to speak to you guys. So I want to welcome her. Her name's Sally Ann Spring. She's an experienced educator, principal consultant, and advocate with a career spanning over 2 decades. She specialises in things like employment law, coaching, professional development, and supports the individuals as well as organisations to navigate complex workplace challenges. So Sally Ann has sat between both. She helps individual people and organisations. So when she comes to us with this conversation, which, by the way, guys, is about companies playing with you, playing in your face with your employment rights. That's what this week's episode is about. Sally Ann can tell you it from both perspectives. She's committed to policy and advocacy, particularly around the Windrush and systematic exclusion. And she's currently developing From Empire to Exclusion, a major research policy report. So I would like to welcome Sally Ann. I met her not long ago when she reached out to me and we had such a great conversation and I knew I wanted her to be a guest. So hi, Sally Ann.
Hi there, Adele. I'm good, thank you. Thank you so much for having me.
Oh, thank you for being here. When I met you, I knew I wanted you to be on this episode. You're so knowledgeable. You've been in this game for so long, and you've just had so much insight. So before we jump into the episode, tell the audience about yourself, your career background, because I also found that really interesting. You've changed and shifted throughout your career. So yeah, share a little bit about who you are with the audience.
Oh, right, no problem. Okay, so going back to when I first went into the labour market, I worked for the civil service. I did that for 23 years. And the last 10 years there, I was a departmental trainer. So I was doing sort of soft skills and management training. But prior to that, I'd become a trade union rep. So the two things couldn't work alongside each other, but I couldn't divorce them from each other in my mind either. So when I left the civil service after doing 10 years as a trainer and soft skills and equalities expert, I then went to actually work for a trade union where I was pulling all of these sort of skills and threads together. Worked for a trade union as a branch administrator and training officer. And then I moved on to work for the TUC actually as one of their employment law lecturers. So I have a teaching qualification and was doing employment law lecturing there. And after that, I moved into a kind of higher grade position with the TUC as an employment law, as a education officer, a regional education officer, where I was responsible for the training for 2,600 representatives in London and the South East area, which I absolutely loved. That was on a fixed term appointment. And then I took on another fixed term appointment where I was responsible for the national education for the TUC for 26,000 reps, which I absolutely loved at that again. Having left that, I then did a kind of couple of stints in education, working within educational departments or on the reception areas. But I kind of really wanted to keep my hand in with employment law. And I was very lucky, actually, during the pandemic. There was a vacancy with one of the trade unions, community trade union. And I went and worked there for about 3 years as a caseworker and then a legal advisor. But Prior to lockdown, I had set up my own company, which is called Serious About Solutions. And where these were all the sort of skills that you mentioned earlier on about my advocacy and employment law and learning and development and so on. That's what Serious About Solutions does. It pulls all of that together. So I'd set that up, but it was only in its initial stages, and then we had lockdown, so nothing else happened. But after lockdown has finished, and I finished working with Community Union, I've kind of gone hell for leather and put everything into Serious About Solutions now, and getting lots and lots of clients because, as you've mentioned just now, all of these liberties that the employers are starting to take with people, and it all really kind of kicked off during COVID, during
Yeah,
lockdown. So,
yeah,
yes, you're absolutely right.
absolutely, absolutely. And I love. Thank you for sharing your career because the audience, my audience, is very varied. A lot of people change careers or trying to change careers, and it's always great for them to hear a story of someone who's done lots of different things, although all very connected,
Yes, I've
still
tried to
very
make it
different.
connected.
Yeah, same with me. Very connected, but still different. And it
Yes.
shows that you can move and you can change. And the fact that you started the business, I think it's so good for people to see, especially see women, and then see women of color like doing all these different things and realizing that it is something that is possible. And I love that you said liberties because it is. These people are taking the liberties out of people, and we're going to help them for them to not take just even if it's one less liberty. We're going to help them with this episode because we want people to understand what your rights are. And I'm going to start off by we just were speaking, guys, before we come on. Obviously, me and the guests always speak, and we were just speaking. And Sally had mentioned something to me that she'd seen a lot recently in this job market. And what I want to say is, I've noticed the job market is very volatile. We all know that. It's everyone in 2024 was like, we're going to wait till 2025 when the job market gets better. And then they realized it got worse. And if I'm honest, the job market is going to continue to get worse before it gets better. I don't even think we've seen the full peak yet, but the job
Absolutely.
market,
I
everyone
completely
knows.
agree.
Yeah, see, volatile. See, Sally Ann has a huge background and she agrees. It's volatile. It's going to get worse before it gets better. When it does get better, I do believe, like at the moment, people are worried about AI and people are losing roles because AI can automate so many things. But I think at some point, AI is actually going to create jobs. It naturally will. But first, we have to, everything's going to fall apart before it gets better. And because of that, we're seeing a lot of shock layoffs, redundancies, companies shutting down. And you mentioned something. You mentioned that something that you'd seen. So I have seen people being taken advantage of when it comes to redundancies and layoffs, and companies not trying to pay the statutory legal minimums and things like that. But you mentioned that you'd seen that some companies aren't even protecting confidential conversations
No,
anymore.
what I'm finding is that, I'm having an increasing number of my clients coming to me saying, I got called in for a protected conversation
Mm-hmm.
without anybody explaining to them what a protected conversation is.
Oh, so not
And
even with an
then
expert.
they have
Oh,
no idea what a protected conversation is. So, classic example, one of my clients currently, she recently had a career break
right.
and she's come back to work now. And there's been lots of changes. And she's thought, okay, let me struggle and get on with what I'm doing
Mm-hmm.
and make a note of the things that I'll have, slight concerns about. And then I'll speak to management about them. So when she got called in for a protected conversation, she went armed with her notebook, expecting to talk about these things.
Right.
And it was a completely different situation. She had no idea what was going on. She completely blindsided, because what they actually was saying to her was, "Oh, we're going to offer you redundancy under these terms and conditions." I mean, and she couldn't take it in because she wasn't expecting that.
Wow.
So when she came to me and said, "I don't know what to do," my advice to her was, "Okay, what you need to do now is say to them, I had no idea what was happening there. I was not in the least bit prepared because I didn't even understand what a protected conversation is legally. And so I need you to please repeat that meeting, but I need somebody with me to
Mm-hmm.
help me to understand."
Yes.
And lo and behold, when she had that meeting with somebody else there, what was being presented was completely different.
You see, that's what I worry about. And this sounds so familiar. Guys, if you're listening, if someone wants to bring you in for protected conversation or any kind of redundancy conversation, they need to write to you first. They need to put
Exactly.
in writing and tell you what they're doing and give you the opportunity to get a representative if you want someone in with you. But they need to lay that out in the message to you, in the email
Exactly.
to you, in the letter to you. They can't just call you in and say, okay, we're thinking of making you redundant. Especially, and this is, guys, I know a lot of you are in the US, the Caribbean, and some of you are even like in India and other places. I want you to know that we're talking about UK law right now. So in the UK, because I know in America different states have different laws, but in the UK, if they ask you for a protected conversation, if they want to speak to you about redundancy, they should have already formally sent you some sort of paperwork first.
Okay. So, what people need to understand about protected conversations is that it falls under what's called Section 111A of the Employment Rights Act. And it means that if you agree to anything that develops from that conversation, you can't then later on take action against the employer in an employment tribunal, for example, unless you've identified that something has happened and there's a whistleblowing element of it, or there's been some discrimination. Those are the only two kind of exceptions in law. Otherwise, whatever happens in that protected conversation you agree to, and then they're not obliged to come up with any alternative arrangements. Let's put it that way. Now, the person that I'm talking about, um, what was being offered to her under that original protected conversation, the little bit she could remember was totally inadequate.
Yeah.
So we now have written to the employer and said, we'd like to have a protected conversation, because what people need to understand is that protected conversations work both ways. The employee can ask for one just as much as the employer can. So we've asked for a protected conversation now for this client, and the employer is not answering,
Oh.
which they're obliged to do. They're entitled to ignore it if that's what they want to do. But I personally find that to be very, very discourteous.
Yes, absolutely. Like absolutely. And if someone finds themselves in that situation and the employer is not responding, is there anything else they can do?
No, because technically there's no record then that the employer is having a conversation of any kind with you. And
Ah, because you didn't.
that's why they're doing it. That's their tactic.
Yes, and this is something I've said to my audience before, and I say all the time when I share posts. If things, guys, things should be written down. Do not
Yes,
take things on face value. Do not like. I don't care if your boss is the nicest boss in the world. I don't care if you think, oh, we're at work, we're like a family. You're not a family. And even in your family, there's chaos and there's people you can't trust. So if there's people like that in your own real life family, imagine at work. Things have to
exactly.
be written down.
Yes,
You need, if it's not in writing, it didn't happen. Your boss could say to you, oh yeah, we're going to give you a raise next month, and then next month comes and you don't get the raise, and you say, where's my raise? And they say, we never said that.
exactly.
Where is your paperwork? Where is your proof? I always say to people, no one likes to have to write things down, but it's never a problem until it's a problem, guys.
Exactly.
I'm the queen of emails. Everyone knows me at work because I will have a conversation with you and then follow it up with an email and then try to get you to respond to me, because I don't want in 2 months you to say, "Ah, Adele, I've been waiting for you to do X, Y, Z," when I know I've done it,
Exactly.
but you will
Exactly.
say I haven't because maybe you haven't done your part. So instead of
Exactly.
you admitting to that, you will make me look bad. So I will always put things in writing. If someone says to me, "Oh, Adele, can we jump on a call and just discuss this?" I'll be like, "Yeah, but let's just cover these points first," and I'll put it all in an email.
Exactly.
If we
Absolutely
have a
right.
if we have a regular conversation and I didn't get a chance to email you first, I will email you after the conversation. Guys, it's the same when your companies, if they blindside you, all you need to do is say to them, hold on, I wasn't sure, I didn't realize this is what was happening. I need a moment. Can we come back? And then send them something in writing, ask for something, go and speak to ACAS if that's what you need to do. Speak to someone like Sallyanne, but don't let yourself be forced into a situation where there is no record of a conversation taking place. There is no record of an agreement taking place. Again, if it is not in writing, it's not real. If you wouldn't take a job offer without it being in writing, don't do anything else once you've got that job without it being in writing. Would you agree,
Absolutely.
Sallyanne?
Absolutely. And what I say all the time is, Employees, workers, staff do not realise the one right they have, which nobody can take away, is keeping notes of everything that's happened. Absolutely important. Keep notes. As soon as you start to become uncomfortable about something, sometimes you can't even put your finger on exactly why you're feeling
Mm-hmm.
uncomfortable, but start taking notes. Charlie spoke to me on September the 16th at 3:15. I was standing by the water cooler.
Yep. Take
Daisy
note.
walked past. Charlie spoke to me about XYZ. You don't know why, you have no idea why Charlie's conversation is niggling at you, but it may become apparent 2 or 3 months later.
Mm-hmm.
Make a note of it. It's really, really important. As soon as you start to get uncomfortable about things, start keeping a note of it.
I totally agree with that. I've been in a situation where I felt uncomfortable about conversation with an employer and I wrote it down. And I'm not going to lie, I blindsided my employer and I said, oh, you know what we just discussed? Do you mind signing this to say this is what we discussed and this is what we've
Right.
agreed?
Well, that's the
And
other
they,
bit of advice that I give.
and
I
they,
say,
oh, is it? See,
yeah,
and they very much were like, no, Adele, I don't, like, no. And
yes,
that was my first alarm and my first red flag.
exactly.
And in that moment, I knew something was happening and I took it from there. And I know a lot of people will say, oh, Adele, I don't know if I'd have the confidence to do that. And this is why I tell you, okay, back it up with an email. If they are not willing to respond to the email, they are not willing to sign something to say, this is what we have discussed. That is your first red flag. That is your sign that you need to have no more conversations with these people without someone else being present.
Absolutely. I say to people all the time, if you have a conversation um, and you're feeling uncomfortable about it, make a note of it. But if it's a member of management, perhaps, or maybe not so much a colleague, because that might ruffle feathers. But if it's a senior member of staff, then you know, go ahead with the meeting, have the conversation, a discussion, whatever it is. And when you get back to your desk, you send an email to say, I refer to the conversation we had today at 2:15, wherein you asked me blah 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 blah. I responded blah 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 blah. For the record, could you confirm that this is an accurate reflection of the conversation? That's all you're asking. Is this an accurate reflection of the conversation? Yeah, so I always recommend that when people have a meeting with management and they feel uncomfortable about it, or something has happened in the past which hasn't been resolved, and so there's things up in the air. Having had the meeting with the management, when you go down to sit at your desk, send them an email or get back to your workstation, send them an email to say, I refer to the conversation we had earlier today at 2:15, wherein you asked me, I answered, I asked you, you responded XYZ. Please confirm this is an accurate reflection of the conversation.
Totally agree. I
Now,
totally agree.
if
And I
if they
also feel like,
agree, fantastic. If they
yes.
don't agree, again, fantastic. Don't push
Mm-hmm.
them.
Yes.
Don't push them for it, because if you need to rely on that evidence later on, whether it's an investigation that's going to happen at work or it goes to an employment tribunal, somebody else is going to look at that and say, well, why didn't you confirm that was an accurate reflection of the conversation?
Exactly. And what I like that you said is don't worry, don't respond, because don't make yourself look more problematic than you need to.
Absolutely.
Ask for
Absolutely.
it. And if they don't give it to you, that's also fine because we don't want to now be problematic. Also, there's a way of you asking for things that doesn't automatically get everyone's back up. Like when I send those emails, yes, people just think I'm anal. They're just like, oh, Adele, why? And I'm like, oh, you know what I'm like? I like to keep a record so I remember. My memory's rubbish. Truth is, my memory's amazing, guys. My memory has always been amazing. But actually, I'll say anything because I'm just like, I want it to feel relaxed and chilled. And I want
Exactly.
whoever it is that I'm talking to want to respond to me. So they'll be like, Adele, how come you emailed me? I'll be like, oh, I forget stuff. I just need to have records of stuff because my memory's
Exactly.
rubbish. You don't have to make it feel really combative. And I think that's the important
Exactly.
part because you're still going to have to go to work the next day or for the rest of the afternoon or whatever point of the
Exactly.
day it is.
Exactly.
So it doesn't have to be combative. And if you ask them to respond and they say no, and then you just let it go, they'll be like, oh, okay. maybe she's not being problematic, because initially they're going to think you're being problematic because you asked. But
That's
if
right.
then when they say no, you're just like, oh, okay, they'll be like, oh, it will throw them off guard.
Exactly.
And then they'll
Exactly.
probably after that start dotting their I's and
And
crossing their
crossing their
T's.
T's. Yes.
They will do what they're supposed to do and be on their P's and Q's, because that now they're like, oh, maybe this person knows a little bit more than I thought they knew.
Yes.
Or actually, maybe I can't play with this person the way I thought I could. So I think what Aliane is saying is so important, guys. And I know some of you listening are probably like, I've never been in this situation, Adele. Just because you've never been in it doesn't mean you won't. And for the people that have been in it and maybe you didn't go down this route, now you know for next time.
Yes. Absolutely.
We can all learn. I don't care if you're 30, 40, 50. It doesn't matter which point in your career you are at, what age you are at, you can always learn. These things I was lucky enough to learn when I was quite young. I had a manager when I was like 19 or 20, and she was amazing. And she always said to me, Adele, if you didn't write it down, it didn't happen.
Right.
She always said to me, she said, Adele, if it's not in writing, it didn't happen, I don't care. And I'd be like, what? She'd be like, Adele, if it's not in writing, I don't care. And she would force me every conversation. And I'd be like, why are you making me waste my time? Remember, I'm a 19-year-old, 20-year-old. Like, oh my gosh, all the time you want me to write it down. Until there was an incident at work. And because I'd done everything she told me to do, the other person had zero leg to stand on.
Exactly.
They couldn't go down a grievance route. They couldn't go down the tribunal route. There was nothing because everything was documented, signed, everything.
Absolutely.
And this is the thing. It needs to be, you will never, there might be times you might do something for 2 years, leave that company and never need any of that documentation. However, you may need it. So isn't it better
Exactly.
to have it and not need it than to not have it when you do actually need it? So I think that's really, really important.
This draws parallels with when I'm sort of doing personal development training as well,
Mm.
and dealing with performance management and appraisal systems. And I say to people, make sure you keep records of everything that's happening. If you've
Mm-hmm.
have a fantastic review from a client or a customer or a service user, what did you do to make that person really, really happy? Make a note
Yes.
of it, because when you're arguing later on that you need to, you should be getting an upgrade with your appraisal or
Mm-hmm.
a pay rise, you need to be able to evidence it. And I say all
100%.
the time that if you're sitting here now in November or October wanting to do a review of the kinds of things that you've done, writing in it today is going to be a completely different feel from when the incident occurred.
Yes.
When you
Yes.
write it with enthusiasm,
Mm-hmm.
it's a completely different feel to it. Equally, if you were really distraught and you write it at that time, it's going to be a completely different feel from when you look back on it 6 months later. I remember I was upset, but it's not going to have the same impact. Does that
No.
make sense?
Yeah, 100%. It's
So,
not going to have
so
the same vibe. It's not going to have the same feeling.
exactly,
You're going to have more reflection. So you might be like, oh, maybe I overreacted. When actually, at the moment, you didn't overreact. But when you look
exactly.
back, you might think differently of it. And I love that you said that people need to evidence receipts. I say this all the time: receipts, receipts, receipts. You
Yes,
should have proof and evidence. Like if I'm asking for my pay rise, my boss isn't thinking about all the amazing things I've done. And even if they are, they don't want to give me the money. So they're not thinking about
exactly.
all the amazing things I've done. But if I've kept a log of all the amazing things, when it comes to that review and they're like, oh, Adele, we're only going to be able to give you like 2%, not the whole 5. And I'm like, oh, but I did this, 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 this. And I'm
Exactly.
committed to continuing to do these things. However, I'm going to need the 5% pay rise.
That's right.
You can't do that without receipts. And I say to people all the time, being in the building is not enough. Being in the building at work, just because you turned up, that's not enough to get your pay rise. That's not
Yeah,
enough to get your promotion. That's not enough for the next step. The receipts, the evidence, that's what you
exactly.
need. So make sure you've got your receipts on hand, on deck, ready to go. And the same when it comes to when there's a problem. If you don't have your receipts on hand, if you don't have your evidence, your proof on hand, it basically didn't happen. You have no
Yes.
proof. So I think that's really important. Um, Sally Ann, while I've got you, I want to ask you about redundancies because they're happening so much at the moment. Layoffs,
Yeah.
redundancies. Sometimes it's like a shock out of nowhere.
Yeah.
Companies closing whole departments, moving departments offshore, which I've noticed a lot recently.
Yes.
Before companies stopped doing that. So a lot of things got brought back to the UK. There was a lot less overseas call centers.
Yeah.
But now everything's moving back again. they're getting labour from outside of the UK, and whole departments are losing their jobs, and then it's being outsourced offshore.
Yes.
What? Firstly, question, and I know the answer, but I want you to let me know from your experience. Can
Hmm.
someone negotiate a redundancy package? That's the first question I want to ask.
Yes, redundancy packages can be negotiated,
Okay,
but
I love that.
you need to be careful to
Mhm.
make sure if you are going to approach the employer
Mhm.
to negotiate a redundancy package, make sure that you know exactly what the statutory package would be in the first place.
Yes.
So whatever you do, don't go into a redundancy consultation or negotiation meeting and then end up having less than you would have done if you had
Yeah.
settled for the statutory requirements.
Absolutely. This happened to someone I know. They were like, "Oh yeah, we'll offer you 7 grand." Her statutory was 8. So I was like,
Right,
hello. Legally you're allowed 8. So even if you did nothing, even if you sign no paperwork, they make you redundant, they have to give you 8. They were asking her to sign all sorts of confidentiality clauses and all sorts
right,
for less than what, and she was like, "Oh, 7 grand." I was like, "You're allowed 8." She was like, "What?" And I said, "Plus you're allowed your annual leave that's outstanding." She was
right.
like, "What do you mean?" In the end, her package was almost 10 grand, but she would have happily taken 7
Yeah,
because she hadn't looked into what she was legally
yeah. And
allowed to
that's one of the
take.
games that the employers play.
Exactly. 100%. And I like you called it a game because it is a game.
Yeah,
They will play cat and mouse with you and they will be like, "Oh, we're giving you 7 whole thousand pounds." Um,
yes,
guys, if you were entitled to 8 or 10, imagine accepting 7 and signing that paperwork when you was entitled to more, but you just didn't look. So
yes,
listen, we have access to the internet readily these days. Check your statutory, what you're allowed. Also,
exactly.
check your contract. What does
Yes,
your contract say about redundancy? Because I remember in one of my jobs, they offered an enhanced redundancy package.
right. And
I was a
that's
senior
the thing.
manager.
If you are going into a redundancy negotiation, then you should be really expecting to come out with an enhancement.
Exactly. And I remember my contract in one of my jobs gave it was like you get the statutory plus an extra 4 weeks
Right,
plus your leave if you've worked for the company for a certain amount of time.
right,
Now I wouldn't have known that if I didn't go back and read my contract.
right.
And also, I want people to also know if your contract says, for instance, just randomly, because I've seen this before, you're not entitled to redundancy or maternity leave, which I have seen in a contract before. I want you to know that a contract cannot override UK law.
Absolutely.
It cannot. So even if your contract says something ridiculous, like you are not entitled to redundancy, please know that under UK law, if you've worked for somewhere more than 2 years, you are entitled to some sort of
Exactly.
redundancy. So, and maternity, all of that. UK law overrides any contract. So if the contract goes against UK law, the contract actually isn't valid. And I want people to understand that
Yes,
because
and
I've seen that
I'd to
before.
explain to people as well that, you know, when you start a job, you get your contract, you get your terms and conditions,
Mm-hmm.
and you get your particulars.
Yes.
Now, all of those documents will say things like, you know, and you've got to abide by the principle, by the policies of the organisation. And you need to understand, guys, that if your organisation's policies are better than the statutory or legal requirements, for
Mm-hmm.
example, most people, you know, employers now, you know, you're entitled to 28 days a year annual leave.
Mm-hmm.
If your contract says that you're entitled to 32 days a year annual leave plus bank holidays, etc.,
Mm-hmm.
your employer can't turn around and only give you 28. Because if your
Yes.
contract says 32 or your
Yes.
policy says 32, then that becomes the legal requirement for you.
Thank you for saying that because your contract can't be less than UK employment law, but it can be more
It
than.
can be
And if
more.
it's more than, you can hold them to the more than.
Exactly.
So it works
Exactly.
more in your favor because you can they can't hold you to less than what the legal UK requirement is. But if they
Exactly.
offer you more, they can't now say, "Oh, we're only going to give you statutory." So if you've got enhanced sick pay and that's what you signed in your contract, but then they decide that, "Oh, you've taken 4 days sick, we're only going to pay you statutory." If that's not what your contract says, legally they
Exactly.
can't do it. And I love that you said that, Sally, because I do know that a lot of people don't actually know that. They think
Yes.
that, oh, as long as they're getting the statutory, the company can do it. It all depends on your contract. And most people, I'm going to be honest, most people read their contract right at the beginning when they start the job and never
Yes.
look at it again.
No, that's right.
It's an
And
active
I think it's
document, guys.
incumbent upon us as
Hmm.
workers to make sure when policies are revised, you
Hmm.
need to make sure that you're looking at those policies. So I think everybody should give themselves, I don't know, even if it's only half an hour a month, to
Yes.
sit and flick through the intranet
Hmm.
or whatever system that they're using at work. Wherever policies have been updated, you need to have a look at those policies. And I'm really sorry, I'm going to kind of deviate things for a second here, Adele.
Hmm.
There's also the point where people may be taken through a grievance or disciplinaries procedure.
You
And
must be reading
I
my
have
mind, Sally Ann, because that is my next question. So let's go. Tell me.
I've dealt with cases where people have been hauled over the coals based on a particular policy.
Hmm.
And when I've had a look at it, well, why are they using this policy? This policy is out of date.
Right.
This policy should have been reviewed 6 years ago. Or, better still, they've revised the policy and after the person's been suspended or whatever, they've revised the policy. They
Mm,
then send the new policy, and I then have to explain to the people, no, but this policy has only become effective from this date.
yes,
They're dealing with you at that date, previous dates, and so therefore, whatever policy was in place at that time is the one that they need to be adhering to for you. And people sometimes don't realize that.
absolutely. They can't change the policy midway through
That's
your
right.
grievance period. And you must have
Yeah.
been reading my mind because my next question was going to say, I was going to ask you, grievance has been happening a lot lately. How can people advocate for themselves? So you just gave me an example right there. That's
Right.
a really great way that people can advocate for themselves by making sure that things are up to date and they're actually being treated with the up to date documents, not with like, and people aren't trying to update halfway through. So are you
Exactly.
being, if a document says on it, this will be updated every, like you gave the
Every
example,
three
6 years
years or
or
whatever.
every three
Yeah.
years, and they've not updated it, the document is like it's not an up to date document. It's not
Yes.
updated. So what are they holding you to? Because that
Exactly.
document is now out of date because it states on their document that that it must be reviewed every 3 years. So it's
Exactly.
really important. Are there any other things when someone's going down a disciplinary that they need to be mindful of and they need to advocate for themselves
Right.
so they
So
can maintain some type of control?
absolutely. So number one, make sure that investigations are being done fairly.
Mm,
Um, who is the investigating officer? So a lot of organisations use external people to do their internal investigations. Which, by the way, Serious About Solutions, we do investigations as well. So yeah, a lot of people use external organisations to do their investigations, which is probably the fairest way.
yes, I agree.
But I have dealt with somebody before who the investigating officer it was very confusing. It was confusing because the organisation was using the same investigating officer for something else that was connected with this particular individual. And so there was a conflict of interest.
Right. And I find that in a lot of small companies.
Yes, yes. First thing I would say, if you belong to a trade union,
Mm,
get onto your trade union right from the start and
yeah,
get them to support you through. Your trade union should be able to, if your organisation allows you to have somebody with you at an investigation meeting, your trade union should be providing that support. Don't sign anything if you're not comfortable.
yeah,
If you go into an investigation meeting and you get thrown some questions and you don't know the answer, then you need to say, I don't know the answer to that. I'll need to go away and find out and come back. The
love
worst
that.
thing you can do for yourself is allow yourself to be browbeaten into giving an answer there and then later on regretting it. So
Yeah,
if you don't know the answer, you don't know the answer. They should give you an indication of what it is that you're going into the investigation meeting to discuss in the first place. Um, like I say, if you can have somebody with you, if you don't belong to a union and you're allowed to take a colleague in with you, and there's a trusted colleague that you can take in with you, that's all the better, because sometimes these environments can be so emotive that you're not hearing what it has been said in the right way, or you provide an answer to something and then it gets twisted. So if you
Yeah.
have a witness in your meetings with you, then that provides some balance.
Hmm.
Um, Coming back to what we were discussing earlier on, Adele, receipts, receipts, receipts.
Yeah.
Keep as much evidence as you can and refer to that evidence when you get called into these types of situations. Um, Again, like you say, policies, make sure that you know the policies.
Yeah.
And but if it comes to a disciplinary, if you get written to and asked to appear at a disciplinary hearing and it doesn't say what the worst likelihood is in the invitation, then that letter is not actually being presented in the right way.
Yes, I love that you said that, because I know someone who appealed. They were they were sacked, but they appealed it because the letter never said that could have been an option,
Right.
and they won their
Absolutely.
appeal. They won their appeal because
Right.
the letter never stated what could actually be the potential outcome
Right.
of the disciplinary hearing. So it was deemed unfair because it didn't tell them. All it mentioned in there was you could end up with a warning.
Right.
It didn't say anything about potentially, like, it didn't give a list.
Right.
So I like that you said that.
And I mean, they don't have to give a list, but if
No,
if if dismissal is the worst thing that could happen, then they have to say
yeah,
that. They have
they
to
have
say
to
that in
say
the
what the
letter.
worst is. If they say in the
Yeah.
letter the worst is the warning and then you get dismissed, that's a problem.
Exactly.
Yeah,
Exactly. That's a breach of ACAS um, guidelines.
yeah.
If they
And for those who don't know what ACAS is, Sally Ann, can you let share
that's
with people who what
that's
ACAS?
arbitration, conciliation, and advisory service.
Oh, lovely. I like that you know their whole name.
So basically, they are there to act as a go-between when there are issues or a bit of conflict with the employer. Which brings me back to another point that you and I were discussing briefly before we started the podcast, Adele, around settlement agreements.
Yeah.
So ACAS will assist with those as well, but that's also something that we could consider under the guise of the protected conversations.
Mm.
So one of my previous clients worked for an organisation for a long time and um, has had a car accident, which has resulted in um, quite extensive injuries, and she's now covered under Section 6 of the Equalities Act. She has a disability, or a number of disabilities, in fact. And it's causing problems, has caused problems with the employer in terms of her being there on site when they have certain meetings because they need her to be on site and blah, blah, blah. So she had a protected conversation whereby she said to them, listen, I'm prepared to leave the organisation if I get a payout of X amount of money and a reference stating that,
Yeah.
I was up to speed, or, overperforming, etc., etc. And then you have a bit of negotiation between the employer and you, and and it goes on, and then eventually now they gave a settlement, so she got a certain amount of money and was happy to walk away with that. So that kind of thing can happen, even when somebody thinks that perhaps if somebody gets called up for a disciplinary and they think that they're perhaps on a bit of a sticky wicket, they can um, broach a protected conversation with a
Hmm.
settlement agreement.
Yes.
And the settlement agreement may be, listen, we're not going to give you any money, but we are prepared to not mention again that we brought you up for a disciplinary, because maybe somebody's professional license may be at stake.
Yes.
And that
and that's
that kind
and
of
that's really, and I
circumstance.
think that's really important because I come from an education and a childcare background, and that can happen sometimes. Um,
Yes.
And also, it might be that you just want to be able to get your reference.
Yes,
So you just want that agreed in the settlement. You want that your reference is going to say that you're going to be able to get a good reference, and it's going to be
exactly.
like, and maybe that. And sometimes in those settlements, you can actually agree with them. You can go back and forth and agree exactly what the reference is going to say.
Exactly.
Whether they're going to do a factual reference, or if you've been there for years, whether they're willing to put a little bit more in there.
Yeah,
But you can get that all agreed under settlement. And again, like Sally Ann said, within the protected conversation.
that's
Like, it
right.
has to be within that protected conversation. Don't just be going and having random conversations, guys, with
That's
people saying,
right.
I want to
Yeah.
broach a settlement. You need to approach it properly, and it needs to be protected. And someone like Sally Ann is the sort of person you would reach out to find out how to go about that, so that you know that your conversation is actually a protected conversation and it's not just a normal, regular, everyday work
Exactly.
conversation.
Just a management conversation.
Yes, so I
And
want to make sure that you guys know that, and that you know that someone like Sally Ann, and her business is able to support individuals with things like that.
yes. Now, I don't have a law degree.
Hmm.
So, for that reason, the protected conversations that I've been dealing with, the Section 111As, when we're talking about the reference, yeah, that's great. I deal with that. Or when we're
Yeah.
talking about money,
Hmm.
pylon,
Okay.
um, and all of that sort of thing,
Hmm.
which is payment in lieu of
Yeah.
notice, um, holiday pay, all that sort of stuff, I pass that over to a professional colleague of mine, um, because he has the qualification, the legal qualification to be able to do that, and then he'll go into the negotiation on with the employer
Got
after
it.
I've taken it to a certain point.
Yeah.
Then my professional colleague will pick it up from there.
Amazing. I love that. Oh, Sally Ann, this has been such a good conversation. I feel like I could talk to you for ages about this stuff. And I feel like you have covered so much for everyone. We've spoken about disciplinaries, grievances, how to advocate. I love all the tips you gave for advocating. Before I let you go, is there anything else you want to tell the audience about this, on this topic? And then also, can you let them know how they can connect with you, work with you, all the
Yeah,
things?
absolutely. Okay, so the only other thing that I want to say to people, I'm finding more and more now that people are wanting to take their case to an employment tribunal. And if you want to take something to employment tribunal, there is a lot to consider, a hell of a lot to consider. I'm not trying to put people off, but there's a lot for them to consider. So I would suggest that anybody who is thinking along those lines or knows somebody who's thinking along those lines attends one of my workshops. It's not because I'm trying to promote my workshops, but it's because I think that people actually need that information before they commit themselves to the whole employment tribunal process. And the reason I say that is because the very, very first case that I dealt with somebody taking something to employment tribunal, this woman was amazing. It took so long to get it to the tribunal that by the time it got there, 2 years, by the time it got there, she'd developed full-blown Parkinson's, and
Oh
her
no.
medical specialists were convinced that it was the workplace stress that had caused that.
Wow. That's really
Um,
sad.
and then it took a long time for them. By the time she had a hearing, then had to go back for another remedy hearing, blah, 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 blah. And then within 6 months of that was the final decision, she passed away. So I'm telling
Oh
you,
my
it
god.
takes a toll
The
on you.
toll, yeah,
It's
I definitely agree.
exhausting. It's
It can be exhausting and stressful. I remember once I was going to
absolutely
take someone to tribunal, and then I was like, do you know what? It's not worth it. And then in the end, I went down a different route and I got what I wanted. But I remember initially thinking I'm going to go to tribunal. And then when I looked at it all, I was like, it wasn't worth it. And
right.
also, I like that you brought up tribunal because, guys, I've been on, obviously, you guys know I've been in HR and I've been on the other side. I know of people that have tried to take the employee to tribunal, and there are options that you have to choose when you take them to tribunal. They've literally chosen the wrong option. They've said, I want to take you to tribunal for discrimination, and it didn't come under discrimination. So it got
Right.
thrown out. It got thrown out before it even got into tribunal. So you guys, you need to get help if you're not sure, because if you do the wrong thing at the start, it won't even get to where you want it to get to. If you put it under the wrong, if you categorize it incorrectly and say, oh, it's discrimination, but actually it wasn't meant to be discrimination, it should have been under something else, then it could be a problem. So
Absolutely.
thank you so much for bringing up tribunal.
If I can just say, Adele,
Hmm.
over 60% of the cases that are submitted to a tribunal
Mhm.
are not accepted. Over
See,
60%.
60. Look how high that is.
And are either
Exactly.
because, like you say, it's not been completed correctly,
Mhm.
or because it's out of time.
Yes.
So please, please, please get in touch with me if you need to, if you're thinking along the lines of employment tribunal, if you're even in a situation whereby you're facing a disciplinary, please get in touch with me, because I run a couple of workshops. Well, I run a workshop of a series of workshops for employment tribunals: how to submit the ET1, what to do when you get the ET3 back, considerations about settlement agreements, how to manage your case, and then what happens at the hearing. They're all 1 hour, 1.5 hours, sorry, each of those workshops. And I also have a workshop on disciplinaries. So what you should do, what you should expect, um, how you should prepare your notes, or what kind of notes you should be preparing when you go in, because this is all about prepare, prepare, prepare. If you're not prepared with any of these things, you're not going to get anywhere.
Oh,
So,
thank you. Where can let the audience know where they can connect with you? What should they
okay,
do?
so if you go onto my website, www.seriousaboutsolutions.com,
Mhm.
or email me on info@seriousaboutsolutions.com.
Perfect. And both of those will be in the show notes, guys. So if you're listening, if you scroll down in the show notes, you'll be able to find them, and you can just click on the links and head straight over there. Um,
I've got a number for you as well that you
oh, go
know.
on.
Yeah. So the number for me is 07480 687 458.
Thank you. Well, Sally Ann, thank you so much for
You're
joining
very
me.
welcome.
Guys,
It's been
make sure
great.
you reach out to Sally Ann, because she is a wealth of knowledge and she will be able to support you through a lot of things. We are not going to let companies keep playing in our face. Let's advocate for ourselves. Let's do what we need to do. Let's try and take back some control. Listen, you can't control if you get made redundant or if you're laid off. You can't. But you can control what you do through those processes. So again, Sally Ann, thank you so much for joining me. I've really loved this conversation. Um, and yeah,
Thank you for having me. Thank you for having me. Just make sure you get knowledged up, everybody, because if you have the confidence of knowing what you need to know, then you don't need to be confrontational.
love that. Thank you so much. And guys, I will speak to you on the next episode. I hope this episode gave you exactly what you needed and motivated you to confidently take steps towards your next career move. If you enjoyed it, screenshot and share it on your socials, tag me on Instagram, and come join my community of amazing women working on leveling up their confidence and careers. Thanks for listening, and see you next time.